say so because it is not an academic exercise suggesting something that is of substance, because he has to show exceptionality as to why the interdict must be granted. And the reason it is so is because it's a separation of powers issue we're dealing with here. So it can't be a run-of-the-mill that you just interdict the workings of another branch of government without showing the exceptionality. And of course, the president does not show exceptionality, neither does he plead exceptionality. And for that reason, and that reason alone, his argument cannot stand.
The panel's duty is to look at the evidence on paper. And, of course, it does allow it to extend even to the president to say that, can you give us a version? But it's actually not even obliged sometimes. I mean, as long as then they have sufficient, but then it is that one they're allowed. But they're not allowed to go outside. So one has to understand what they come up with in the context of what the rules say they must have in front of them.
You can't make a prima facie case by saying, I have a right to review. That's act. Second requirement of Sitrugelo, irreparable harm. Where is the harm? The only harm you can talk about with the greatest respect is the harm that has been pleaded. What does the president say? He comes here and he says, well, I cannot be put through the humiliation of accountability.
The legal counsel was also at pains to explain to the court that the Parliamentary Impeachment Committee is not unlawful in wanting to carry out the order of the Constitutional Court.
When Parliament decide on a process such as continuing, this court will not interfere in that process at all, unless it is suggested that the process chosen was unlawful, unconstitutional. And there's no suggestion of that. So he is asking this court to interfere in a process which is not unlawful.